Introduction as far as the jury instructions. Members of the jury, you have found each of the defendants guilty of one count of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for the crime of first-degree murder is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say, however, during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendants may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of the trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors outweigh any mitigating circumstances the defendants proved by the greater weight of the evidence. Finally, you will decide whether each defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: as to defendant Rashad Murphy, first aggravating factor, the defendant was contemporaneously convicted of a felony involving use or threat of violence to a person. The second one, the defendant knowingly created a great risk of death to many persons. The third one, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And four, the capital felony was committed by a criminal gang member. As to defendant Isaiah Chance, as to first-degree murder, the first aggravating factor is, as alleged by the state, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The second aggravating factor, the capital felony was committed by a criminal gang member. As to defendant Sean Gathright for first-degree murder, the first aggravating factor is the defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person. The second aggravating factor, the defendant knowingly created a great risk of death or harm to many persons. 3. The capital felony was a homicide and was committed in a cold, calculated, and premeditated murder manner without any pretense of moral or legal justification. As to defendant Davion Murphy for first-degree murder, the state alleges the following aggravating factors. 1. The defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person. Second, the defendant knowingly created a great risk of death to many persons. Third, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And 4, the capital felony was committed by a criminal gang member. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as itself an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for a defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, I will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, I will then conclude with final instructions to you. After the final instructions are given, you will begin your deliberations. Again, you should not form any definite or fixed opinion until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you should not discuss the case amongst yourselves. Your decision must be based solely on the evidence or lack of evidence and the law.